Namaste all. My name is Vijay Chittiboina. I am a law teacher. This video is made in the interest of the law students, the future lawyers, who requested me to give a brief on how to deal with the case laws in exam point of view. I am going to discuss the basic fundamentals in dealing a case law. The students will be asked the case laws in the mid-semester exams and end semester exams anywhere in the part B or part C, where usually part A asks short type questions and part B asks essay type questions and part C a mandatory section asking case law, or sometimes the case laws type questions will be asked in part B itself. I will give a brief on how to deal with this particular case law aspect. The case law should be dealt under different heads like facts of the case, framing of issues, legal proposition, relevant case law, decision and outcome. Each head may contain different weightage. I'll give the scheme of evaluation for case law section. First, suppose if the question is for 10 marks, the weightage for the individual parameters shall be for facts of the case 2 marks, framing of issues 2 marks, legal proposition 2 marks, relevant case law 2 marks, decision and outcome 2 marks. For suppose if the question is for 8 marks, the weightage of the individual parameter will change like facts of the case 1 mark, framing of issues 2 marks, legal proposition 2 marks, relevant case law 1 mark, decision and outcome 2 marks. Here the most weightage will be given for the framing of issues, how good you frame the issues, and also the legal proposition means under what reasoning, the rationality you have given the decision. Next, and also for suppose if the question is for just 5 marks, the weightage for the individual parameter shall be like facts of the case 1 mark, framing of issues 1 mark, legal proposition 1 mark, relevant case law 1 mark, decision outcome is also 1 mark, means each mark for every separate head. And here is the sample question. You may pause the video and go thoroughly of the sample question. What are the facts in the case? Facts are usually the information about the case given by the client to the lawyer. The lawyers base their arguments on the facts given in order to win the cases in the court of law. Coming to students, in exam point of view, the students are asked to analyze the case by focusing on the most important facts and using that information to determine the liability aspects. Students usually confuse that already the facts are mentioned in the question given, so do we need to write the facts of case again? Yes, you need to mention the facts of the case under separate heading because there will be both important and unimportant details. Please note that not every detail is important. For suppose if you look at the sample question, it was said that plaintiff has taken a bus and went to Secunderabad. So going on a bus is an unimportant fact here. What if he goes on a train to Secunderabad? How is the mode of transport important here? Why? Because here the issue revolves around the beer and not the bus. You may look at the facts of the case mentioned here in the right manner. Issues involved. Framing issues is among the most important part of a case. Issues create the boundary of a legal controversy. The issue is a statement of the question of law that the court shall look into it in order to decide the case. A case may involve more than one issue. You may look into the issues framed here to the given sample question. What is legal proposition in a case? It refers to the ratio of a court judgment, that is, the reason for the decision, which is legally binding element of the case and that which creates the precedent. In the given sample case, it is a case involving tort of negligence. As there is no specific enactment or any codified law for torts in India, so we have not mentioned the act and provision here. For suppose if it is a dispute related to breach of contract, you have to mention the specific enactment, which is Indian Contract Act 1872 and the relevant provision dealing the breach of contract. What is a relevant case law? Citing a relevant case law makes your decision authentic. Case law refers to the collection of precedents and authority set by previous judicial decisions on a particular issue or topic. You shall quote at least one or two relevant case laws. You also need to know what precedent means. Precedent is an earlier event or action that is regarded as an example or guide to be considered in subsequent similar cases. Here, I have quoted a relevant case law which is a similar dispute to that of the facts of the sample. Here comes the last one: decision and outcome. In the decision and outcome heading, you will be determining the liability aspects that are framed in the issues, usually point to point basis. For example, whether the plaintiff is entitled to any damages or not. In our present case, the plaintiff Rahul is entitled to compensation. That's done. I wish you all the best. Do subscribe for more videos on legal aspects.